Now, the border crisis and the debate over what to do about it is certainly one of the most divisive and hot button issues in our country at present. And when things get partisan and emotional, you are bound to see a lot of bullshit coming from every side. And this issue does not disappoint in the dishonesty and melodramatics. So today, on Legalese, we are going to be looking at a couple of these false claims and emotionally driven narratives surrounding the border dispute under the case DHS versus Texas. Hey, greetings everybody, and welcome back once again to Legalese. Now, as always, I am your host, Bob, and I want to thank you all so much for joining me here today. And if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, real quick, I just want to remind you guys, you can find out more about the show by going and checking out our homepage over at legalespodcast.com. And if you want to make sure that you always get updates whenever I put out any new content, and I don't just do these videos on YouTube, there is a podcast version of the show over on Spotify. I also post to alternative platforms like Rumble and Odyssey, but then also I write a lot of articles over on Substack as well. And if you want to make sure that you get notified whenever I put out new content, all you have to do is go head over to legaleshow.com, subscribe to our newsletter, and you will get notifications anytime I put out any new content. All right, we've got a lot to do today, so why don't we just jump right in? Now, as I was saying just a few moments ago, these false narratives and untruths in this issue come from every side. And so we're going to be looking at one false claim from both sides on this issue. Now, for this video, I had planned to fact check one questionable Republican claim and one questionable Democratic claim from the case DHS v. Texas, and I wanted to include them both in one video. However, by the time I finished writing the script for the Republican claim, it was too long to add on to. So how it's going to work is today, I'm going to be taking a look at the politically biased legal claim coming from Republicans regarding the border protection debate. And then tomorrow, I will be releasing another video where we will be looking at the politically biased legal argument that we see the Democrats making pretty much as a direct response to the Republican claims that we'll be discussing here today. So there have been some recent claims that have really gone mainstream lately among Texas politicians and generally like Republican members of Congress. But with this, all sources seem to lead straight back to Governor Greg Abbott, the notable repube from Texas.
Did you just say repube?
Mm-hmm. Yes, sir.
You mean Republican?
No, sir. The form I filled out when I ran out for Congress said repube on it. It was a professional form, sir. It was typed on paper, maybe even double-spaced.
No, I think you meant repub, short for Republican.
No, sir.
Now, this is the idea that the illegal immigration happening constitutes an invasion. This immigration equals invasion narrative is one that Governor Greg Abbott started disseminating early and often.
Early and often.
Now, here he is saying it last year.
And the governor got the attention of thousands of people today with a tweet about the border. Let's take a look at it. Governor Abbott writing, quote, "I invoked the invasion clauses of the U.S. and Texas constitutions to fully authorize Texas to take unprecedented measures to defend our state against an invasion." He went on to mention specific action the National Guard and DPS are taking at the border. Now, at last check, the tweet has gotten more than 55,000 likes and has been shared by more than 14,000 people. So
Here he is saying it last month.
Was overshadowed by a social media post Tuesday morning by Governor Greg Abbott. He invoked the invasion clauses of the U.S. and Texas constitutions. That
And here he is saying it last week.
And we are here to send a loud and clear message that we are banding together to fight to ensure that we will be able to maintain our constitutional guarantee that states will be able to defend against any type of imminent danger or an invasion.
Now, it would be one thing if he was using the term invasion rhetorically, but the problem is that he has taken to characterizing this increased flow of undocumented migrants as an invasion, as that term is used in the Constitution, and claiming that the Biden administration's policies in responding to this invasion are a violation of the Guarantees Clause of Article 4 of the Constitution. So, here is a full statement that Greg Abbott issued last month on January 24th that elaborates on what exactly he means when he says invasion. So he starts out by saying that James Madison, Alexander Hamilton, and the other visionaries who wrote the U.S. Constitution foresaw that states should not be left to the mercy of a lawless president who does nothing to stop external threats like cartels smuggling millions of illegal immigrants across the border. That is why the framers included both Article 4, Section 4, which promises that the federal government shall protect each state against invasion, and Article 1, Section 10, Clause 3, which acknowledges that the state's sovereign interests in protecting their borders. He goes on, the Biden administration, to fulfill their duties imposed by Article 4, Section 4, has triggered Article 1, Section 10, Clause 3, which reserves to the states the right of self-defense. For these reasons, I have already declared an invasion under Article 1, Section 10, Clause 3 to invoke Texas's constitutional authority to defend and protect itself. That authority is the supreme law of the land and supersedes any federal statutes to the contrary. The Texas National Guard, the Texas Department of Public Safety, and other Texas personnel are acting on that authority, as well as state law, to secure the Texas border. Now, I do want to clarify something here, and that is that I am absolutely not taking a position either for or against the governor's larger point that the Biden administration's immigration and border policies are bad policies. I am not interested here in addressing questions of policy. So the only thing I am speaking to is whether or not the original meaning of the Guarantees Clause in Article 4, Section 4 is consistent with his construction of invasion, and that term includes an increase in migrants illegally crossing our border, as well as whether the Compacts Clause, which is the colloquial name for Article 1, Section 10, Clause 3, is consistent with his construction that it acknowledges the state's sovereign interest in protecting their borders. Now, I'm not one to play hide the ball, so I will just come out and say right now that these claims are completely wrong. They cannot be sustained by any reasonable reading of the text of the Constitution, the original understanding of the Constitution, or subsequent interpretations of the Constitution by courts or constitutional scholars. So let's find out why. So we're going to start by looking at Article 4 and the Guarantee Clause. Now, this clause reads that the United States shall guarantee to every state in the Union a republican form of government and shall protect each of them against invasion and on application of the legislature or the executive when the legislature cannot be convened against domestic violence. Now, this section is called the Guarantees Clause because by its terms, the federal government makes certain guarantees to the states. One of those is protection from foreign invasion, and it continues Congress's prior obligations under the Articles of Confederation. Now, this guarantee is related to the principle that although the several states are decentralized internally, it is to have a substantial common foreign policy and to be seen as unified sovereign in international law. Now, both the Articles of Confederation and the U.S. Constitution, composed 10 years later, were not only frameworks of civil government, but also, and really critically, set out the terms of a military alliance between sovereign states confronted by external and occasionally internal military threats. We are going to be exploring how the framers and ratifiers who gave our Constitution legal force used the term invasion during the drafting and ratification debates to establish its original meaning in this particular clause. Now, the first thing to note is that when it comes to the use of this term by the framers and ratifiers, in a relatively small number of circumstances, the phrase was used metaphorically, such as talking about an invasion of our rights by the government. But second, and this makes up the vast majority of instances which are other than the first example I just gave, the term invasion is always referring to bringing the full and combined military might of the several states and the federal government to bear in cases where one or several states are faced with an armed invasion from a foreign power. For example, at the outset of the Philadelphia Convention, Virginia Governor Edmund Randolph would criticize the so called New Jersey plan for a new constitution by maintaining that his strong legislature and weak executive would yield military weakness. And here he would say, originally, our confederation was founded on the weakness of each state to repel a foreign enemy, and we had found that the powers granted to Congress are insufficient. The body of Congress is ineffectual to carry the great object of safety and protection into execution. What would their powers be over the commander of the military but for the virtue of the commander? Congress are too numerous for an executive, nor can any additional powers be sufficient to enable them to protect us against foreign invasion. Now, later in the convention, Massachusetts delegate Rufus King would observe under the Constitution that was currently under construction in Philadelphia, what are the great objects of our general system of government? First, defense against foreign invasion, and second, against internal sedition. Now, one could perhaps say that these points that I just read are general proclamations about the new scheme of government being debated in the abstract, and there's no reason to assume that the language applies specifically to the guarantees clause, and fair enough. However, despite the fact that Governor Abbott begins with his vague claims that somewhere, at some point, in some way, James Madison and Alexander Hamilton specifically definitely, probably, maybe, possibly agreed with the governor that Article 4 was something they definitely contemplated as applying to the impossibly anachronistic issue of illegal cartels smuggling millions of people across our border. Now, I would contend that James Madison and Alexander Hamilton provably understood that clause specifically and uniquely to refer to armed invasions by foreign powers requiring a military defense to face this hypothetical military threat. Now, the only difference between Governor Abbott's claims of what their understanding of this clause was and what my claim of this understanding of the clause is I can back my claims up with evidence. So the most obvious would be to start with Federalist 44, where James Madison is specifically elaborating on the original understanding of the Guarantees Clause. Now he says, no state shall, without the consent of Congress, lay any duty on tonnage, keep troops or ships of war in time of peace, and to enter into any agreement or compact with another state, or with a foreign power, or engage in war unless actually invaded. Now, throughout The Constitutional Convention and state ratification debates that followed, delegates and commentators used the term invasion over and over. Now, the word invariably refers to an incursion into or against the territory of the state or the nation, and it refers to an incursion that must be met with a military response. Now, when it comes to Alexander Hamilton, one good example would be at the convention when Hamilton was disparaging continental examples of loose federal systems by saying, "Let us examine the federal institution of Germany. It was instituted upon the laudable principle of securing the independency of the several states of which it was composed, and to protect them against foreign invasion. Has it answered these good intentions? Do we not see that their counsels are weak and distracted, and that it cannot prevent the wars and confusions which the respective electors carry on against each other?" Now, the use and understanding of the term invasion in the text of the Constitution doesn't just come from the Guarantees Clause. Now, the word invasion appears in 4 clauses in the U.S. Constitution, all of which relate to military alliance aspects of the Constitution, or what we might today now call a national security architecture. And this, whether considered individually or collectively, these 4 usages plainly refer to a hostile armed incursion into or against a United States territory, and indeed, they cannot reasonably be understood any other way. Now, obviously, the first of these clauses is the one we've already started to talk about. That would be the Guarantees Clause in Article 4 itself, which contains the basic security guarantee that provided a primary inducement for these states to join into a constitutional union with strong national powers. The guarantee of mutual defense against both invasion from without and, upon special request, against domestic violence, which means insurrection or violent civil disturbances from within. Now, to further elaborate, we can turn back to Federalist 44. And in Madison's discussion in Federalist 44 of Article 4, he emphasizes that states require protection against invasion by both foreign hostility and potentially aggressive fellow states of the Union. Now, throughout Federalist 44, he speaks of both invasion and insurrectionary domestic violence as bloody events involving military talents and experience and an appeal to the sword. Now, the next place we find the term invasion is in Article 1, Section 8. This is where the Congress shall have the power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions. And so this clause prescribes the mode of military organization that the founders who opposed the maintenance of a national standing army imagined would be employed to defend the nation and individual states against internal insurrection and foreign invasion. The power of the Congress to call state militias into national service. Next is Article 1, Section 9, Clause 2. The privilege of the writ of habeas corpus shall not be suspended unless when in cases of invasion the public safety may require it. So, Article 1, Section 9 concerns the basic Anglo-American right of habeas corpus, which is the right to demand that a court determine whether there is a legal basis for criminal arrest and detention of every person. Section 9 decrees that this right can only be suspended in cases of rebellion or invasion, and this special exception for rebellion and invasion recognizes that in times of actual armed conflict, normal legal protections may have to be suspended. Of course, however, if Greg Abbott's interpretation were correct, what he is saying here is that this incursion of immigrants illegally crossing the border is a reason for him to deny you your civil liberties, such as your right of habeas corpus. After all, it is to be used in cases of rebellion or invasion. Bye bye, civil liberties. Now, the next and last usage comes from a clause we've already talked about, the Compacts Clause, which is Article 1, Section 10, Clause 3. Now, this clause reads that no state shall, without the consent of Congress, lay any duty or tonnage, keep troops or ships of war in times of peace, enter into any agreement or compact with another state, or with a foreign power, or engage in war, unless actually invaded, or in such imminent danger as will not admit of delay. So, Section 10 of Article 1 reserves to the national government exclusively the conduct of foreign policy. It also prohibits states from maintaining regular armies and navies in times of peace, and it absolutely bars them from engaging in war unless actually invaded or in such imminent danger as will not admit of delay. So, in other words, the constitutional response to invasion is war. Section 10, when read together with the provisions of Article 1, Section 8 that grant Congress the power to declare war, confers the responsibility for national defense for making war on the national government. The Constitution leaves only one narrow exception for emergencies in which states can engage in war if they are actually invaded or under imminent threat of invasion or danger so great that it would merit war as a response. And even then, the plain implication of the opening requirement of consent of Congress together with the concluding exception for dangers that will not admit of delay is that even a state actually invaded cannot make war on its own indefinitely, which is what Governor Abbott is claiming the right to do. But they must appeal to Congress as soon as possible for its consent and support. Which again, he is blaming the Biden administration, but if he is being invaded and if invasion means an increase in the number of illegal immigrants, then the reaction to this invasion is not supposed to be an appeal to the president, but to Congress, which he hasn't done. Now, even though I just demonstrated that the term invasion in the Compacts Clause refers to an invasion in which the proper response is to wage war, which should obviously necessitate an invasion by an armed military force of a foreign power, that really we could stop analyzing this clause right here. But there is one more point I want to address because disproving his interpretation of invasion was pretty straightforward, and anyone could have disproven that claim for themselves in a matter of minutes if they had simply taken the time to look it up and do so as I have just done. But when Governor Abbott brought up the Compacts Clause, he used an old lawyer's trick here, which was to define its meaning by relying on a Supreme Court case. Now, this should be no surprise that he would employ an old lawyer's trick, since the governor is an old lawyer. For those who may not be familiar, before Greg Abbott was the governor of Texas, he had a distinguished legal career, including 5 years as a justice on the Texas State Supreme Court and over a decade as the Attorney General of Texas. And he is employing several tricks that would be hard to spot and untangle without a background in law. And in fact, this this legal sleight of hand that he is using is not uncommon to find being employed in constitutional law arguments. However, what I want to do here is provide you with the tools so that By the time you finish watching this video, you will have no problem spotting these tricks for yourself whenever you come across them in the future. So to start, let's take a quick look at the relevant portion of Governor Abbott's January 24th letter once again. He says that is why the framers included both Article 4, Section 4, which promises that the federal government shall protect each state against invasion, and Article 1, Section 10, Clause 3, which acknowledges, quote, the state's sovereign interest in protecting their borders, end quote. Now, the first thing that you should notice here is that he has explained the guarantees clause with the actual text of the clause, whereas he does not include the text of the compact clause. Just a case citation that you are left to infer is an authoritative interpretation of what the court says the compact clause means. Now, this sort of flip-flopping between specificity and generalities should be a big red flag. And the reason for this becomes obvious when we put the text that he included of the guarantees clause next to the text that he did not include, which is that from the compact clause. And when we do this, the reason he used the one and declined to use the other becomes immediately apparent. So, the guarantees clause says the United States shall protect each state against invasion. And the compact clause says that no state shall engage in war unless actually invaded or in such imminent danger as will not admit of delay. Now, what we see here with the guarantees clause is that, admittedly, the wording here in the text itself is vague enough that it is not immediately apparent his interpretation is wrong. By comparison, the compact clause is facially inconsistent with his proposed interpretation. Now, either this clause confers a right for states to defend their borders from an armed military invasion, or Governor Abbott is suggesting that Texas has the right to keep unarmed migrants from illegally crossing the border by deploying the military to kill them the moment they set foot on Texas soil.
But wait! There's more! Hang on to your seat, baby! Cause this one's a screamer!
Now, there is a second trick being employed here that is actually even trickier to grapple with, and it's all about the way people employ Supreme Court opinions in a legal argument. Now, before we get to the trick, I'm going to need to walk you through some fundamentals as far as the steps it takes to read a Supreme Court case citation and how to identify different parts that make up the opinion of the court. Now, most people see a quotation from a Supreme Court case, just like the one that Governor Abbott used from Arizona v. United States, and they see it quoted rather authoritatively in a context that certainly assumes that the purpose of that quote was very obviously the court officially supporting that interpretation of the compacts clause. That is exactly what his usage of that quote would suggest. And this is what people do all the time. They simply assume that what they are reading in a case like that, when they have a quote from a court case presented to them, is that they are reading a binding decision from the majority of the court. But often, and this is especially true here, as you will soon see, nothing could be further from the truth. Now, the first thing you need to do when you see a quote like this is to know how to look it up in context, using the case citation to pull it up in the Supreme Court's case reporter, which is called the United States Report. Now, a case reporter is a general term for any publication containing the opinions of a particular court or jurisdiction organized chronologically by the date of the decision. Now, to do this, it requires the ability to read and apply a case citation to look the case up for yourself. And a case citation will include the case name, the volume of the U.S. report. It will include the U.S. reporter abbreviation. And this is how you distinguish a Supreme Court case from a citation by any other court. So, a Supreme Court case is always identified by the abbreviation US. Now, the next thing is the case page, which is the first page the opinion starts on in the case reporter. You will additionally often see what is known as a pinpoint citation, which shows you where in the opinion the particular text being quoted is found, and finally, the year the case was decided. So I realize that may still be a little confusing. Don't worry, I'm going to help you put it all together here. So this is the citation that Governor Abbott included in his letter, where he said we could find the quote that he pulled from the Arizona v. United States case. So as we look at the different points of information in Governor Abbott's citation for Arizona v. United States, this citation is to the United States report, and as you can see, it includes the following 6 elements. The first is the name of the case. Second is the volume of the United States report. So this is volume 567. Next is what we talked about, the reporter abbreviation. So when you see US in a case citation, the way you see it right there, that is saying that this is a US Supreme Court case and not any other court. Next, you see the case page. We have the first page of the case is page 387, which means if you go to volume 567 of the court reporter, if you turn to 387, you'll find the very first page of Arizona v. United States. Now, fifth, you see a pinpoint citation. And again, you may need to include a pinpoint citation, which is a citation to the page on which the specific material referenced appears. So if you need to include a pinpoint citation to, for example, a quotation or the holding of a case, you add that page number right after the first page number. And so what we see here is that in Governor Abbott's citation is that the case Arizona v. United States starts on page 387, and the quote that he used will be found on page 419. And then, of course, finally is just the year that the case was decided. Now, once you have pulled up the opinion of the court, you need to identify the different parts of the case, which help you focus your reading. Now, this is why on the show notes page for this episode, I have included a link to the Arizona v. United States opinion being cited here. And I'm going to highly recommend, if not downright insist, that everyone take a moment and go pull up that case brief from the link that I have provided on the show notes page, so you can follow along with me in identifying the different parts of the case in the relevant brief. Now, don't worry, I don't want you to miss anything while you're going and looking that case up and pulling it up. So I'm just going to spend the next minute or two watching the hospital dance number from Breakin' 2 Electric Boogaloo. That way you will have plenty of time to go pull up that case brief without missing anything.
Now jam the box.
Emergency. Sweat.
All right. Now, typically, when you pull up a U.S. Supreme Court opinion, it is going to be comprised of one or more or all of the following parts. So the first part is the syllabus, and this, of course, appears first before the main opinion of the court. Now, this is a summary of the information the court includes to help readers understand the case and the decision. So the syllabus will outline the facts of the case and the procedural history. And the last portion will sometimes summarize which justices authored the various opinions in the case. And it may also include, in fact, it's very likely to include the primary holding, which is the legally binding decision of the court. Now, the next section after that is the main opinion, and this is the court's official decision in the case. Now, in legal terms, the opinion announces a decision and provides an explanation for the decision by articulating the legal rationale that the justices relied on to reach that decision. And finally, we have the concurring and dissenting opinions, because often there are multiple opinions within the document because the justices are not in agreement. Justices who agree with the result of the main opinion or with the resolution of the dispute between the two parties, but who base their decision on a different rationale, may issue one or more concurring opinions. Now, likewise, justices who disagree with the main opinion in both its result and its legal rationale may issue one or more dissenting opinions. So, once you have looked up the case itself, the first thing to note is that most people assume the majority opinion is legally binding. Now, this is actually only partially true. The only part that is legally binding is the primary holding. Now, often the primary holding can be found, as we just mentioned, at the end of the syllabus. So here, as you can see, we have page 387 of the U.S. Reporter, volume 567, which means that we are at the first page of the opinion for the court in Arizona v. United States. Now, at the top, you find the beginning of the syllabus, which is the facts of the case and the procedural history. And what you see is after that, it is followed by the primary holding. Now, after the syllabus, you will find the main opinion of the court, which in Arizona v. United States happens to start on page 392. So this is 392. You can see where the majority opinion written by Justice Kennedy begins. And so the thing to understand here that's very, very important is that this majority opinion doesn't all get equal weight. It is only the decision of the court that is legally binding. Now, the decision of the court is also what we colloquially call the primary holding. And everything outside of the primary holding, which are the explanations and legal rationales for that holding, are considered what is known as dicta. Now, dicta is defined, and I pulled this from Cornell Law, as follows. So, dicta in law refers to a comment, suggestion, or observation made by a judge in an opinion that is not necessary to resolve the case, and as such, it is not legally binding on other courts, but it may still be cited as a persuasive authority in future litigation. Now, while we could have determined that the citation that Governor Abbott was relying on actually comes from a concurring opinion from Justice Scalia, and we could have just turned right to that rather than going through what we just did, the reason I want you to recognize where the majority opinion is, is because I want you to read the majority opinion first to establish the context of the official position of the court. Now, this is important because after you read Justice Kennedy's majority opinion, what will become very clear is that nothing in it, neither the holding nor the dicta, actually have any relevance to the Compacts Clause. Now, additionally, it's worth noting that you that both when you have a concurring and a dissenting opinion in a case, such as the opinion by Justice Scalia that we're going to be turning to in just a second, that Governor Abbott was quoting from. Now, these opinions, even though they're not the majority opinion, they are still considered obiter dictum. Now, that means that, like the majority opinion, that is to say, the dicta in the majority opinion, they may be cited as persuasive, but not binding authorities in future litigation. However, the most important part of the definition of dicta in this instance is perhaps the least obvious part. It would be easy to think that the most important part is the part where it says that they provide persuasive but not binding authority. And in some cases, it would be. However, in our case, the most important part is that not that dicta is not legally binding on other courts, or that it may be still be cited as persuasive authority, but that it may be cited as a persuasive authority in future litigation. Now, what that means is that when Governor Abbott uses a court case like this to justify his own opinion on some aspect of the Constitution, when he quotes the dicta from the case, that is not to be taken as a persuasive authority because it is not being used as a matter of future litigation. Really, the only thing that should be taken as binding is the primary holding. And this means, again, I don't mean to beat a dead horse here, but just to be very clear, this means the only place where it would be proper to do what he did, which is to bring up dicta authoritatively, is as a matter of stare decisis. However, what we're about to see is that what Governor Abbott has done here is actually worse than relied on something irrelevant. Now, while Justice Scalia's concurrence begins on page 416, and I would recommend you actually read the entire concurrence if you're up for it. But if you remember, our pinpoint citation comes from page 419. So let's turn there together right now. So now that we have gone there, we can read the quoted paragraph in text because that will make it clear that what Governor Abbott is doing is twisting the words of Justice Scalia's dissent to say something that is entirely to Scalia's actual assertion. So I've typed it up just to make it easier to read here for purposes of the show. So the relevant portion of Scalia's opinion from which Greg Abbott got his quotation, he says, quote, a later portion of the same section provides that, quote, no state shall, without the consent of Congress, engage in war unless actually invaded or in such imminent danger as will not admit of delay, end quote, which he goes on to say is in accordance with Article 1, Section 10, Clause 3. He then points out that this limits the state's sovereignty in a way that is not relevant here, but leaves intact their inherent power to protect their territory. And so when we read this in context, there is no way to deny that what Scalia is actually saying here is that the Compacts Clause limits the state's power to make war while protecting their right to repel an armed invasion, but that, of course, that has nothing to do with the issue before this court at present. And that's because this case was an immigration case that was dealing with an Arizona statute, not with this provision of the Constitution.
You got me now. You got me now. You got me now. Oh, you figured me out. You fucking income fucking poop. You figured me out. You got me red-handed. You got me red-handed.
Now, that is pretty much all you need to know to look up a questionable or an unclear case where people may try to misuse Supreme Court precedent to support their unsupportable arguments. Now, I suppose I want to briefly be clear here that this is not the way that I would recommend going and reading a full case brief de novo, which just means reading a full case brief from the beginning without consideration of previous instances, proceedings, or determinations. Now, if anyone out there wants to do the extra credit and go get a good lesson on how one can read a full Supreme Court case brief and best understand it and break it down in a manageable and understandable way, a very good friend of mine within the legal blogger community, De Civitate, has written an excellent guide to essentially how he goes about a de novo reading of a Supreme Court case brief, and I will be linking to his article in the show notes. I would suggest everyone go check it out if you're interested. That is really all I have for you guys here today. Make sure you tune in tomorrow for my other video where we will be, covering the questionable legal arguments coming from the Democrats on this same case. And this is why you should definitely make sure right now to subscribe to the channel, as well as doing all of those other things that help to trigger Al Gore's rhythm, including hitting the thumbs up button if you like the video, hitting the thumbs down button if you dislike the video, and leaving me a comment, letting me know what you liked or disliked about the video, or just sharing your thoughts on this topic in general, maybe any questions that you might have about what we have discussed here today, or just your thoughts on anything in general. It is up to you. So anyway, until next time, this has been Bob for Legalese, talking about the Texas border crisis in DHS v. Texas, and of course, as always, Carthago delenda est.
And good luck on the rest of the campaign. Just know that this repube will be voting for you.
Cleavon, if I win, how would you like to come down to Washington and serve as my vice president? Of the hot tub committee.
Are you serious, sir?
Well, yes, we can always use a good repube like you on the other side of the aisle.
Sir, you have no idea how much this would mean to me. When I was a little boy, I put a magic hat on a snowman, and he came to life. I blacked out. I got all dizzy and fell over on the ground. And when I came to, I looked up, and the sky was filled with different colors. We were flying through the air together, kicking our little legs. We were free. We were free. I have that same feeling right now, sir.
Just say yes.
Yes. Yes, sir. Yes, sir. And, sir, don't worry. We will get you the great state of Georgia. I can promise you that, sir. Even though this is a state filled with rebukes, I will take my wife to every single town. She and I will suck as many dicks as it takes to get these votes, sir. That's how much you mean to me. The experiences we had together, I will never forget. Just being friends, you know, not in a gay way, just a politician to another politician, you know, just sharing a warm bath together.
I will go door to door and ask each and every person to have a heart and vote for FDR. I will do that, sir. I will do that.
Motherfucker, like Freddie Mercury. Motherfucker. I got a trunk full of amps, motherfucker. I got a trunk full of amps, mother.